Hello and welcome to yet another episode of the In-Depth series. Do you think that the privileges that are given to the member of the parliaments and member of the legislative assembly with respect to freedom of speech, it is being used responsibly or not? We will find out through a recent judgment of the Supreme Court with respect to it. As Indian citizens, under Article 19, we all have the freedom of expression. But the freedom that is provided to the MPs and the MLAs are different than ours because of the articles that are mentioned in the Constitution and also because of the responsibility they have on their shoulders as the member of the Parliament and as the member of the legislative assemblies. So, we will talk about the case. The name of the case has been mentioned. I am mindful of that fact. Plus, the other important aspects have also been discussed. Let us move ahead without any further ado. And this slide represents what we are going to talk about today. The case, what is the case? With respect to the current judgment that has been pronounced by the Supreme Court that there is not any need of putting curbs on the freedom of expression or freedom of speech of the member of parliaments and member of legislative assembly. The parliamentary privileges and immunities under the Constitution. What are the other privileges that are enjoyed by the MLAs and MPs? Why is there a need for freedom of speech? To the parliaments and legislators, the concerns that are associated, the judgment and conclusion in the last. Let us move ahead and first of all talk about the case. The case has the name as Kaushal Kishore versus the state of Uttar Pradesh. It is related to the Bulandshahr rape incident of 2016 when Azam Khan back then termed the incident as a political conspiracy and nothing else. So he ridiculed and rubbished such an incident as a political conspiracy. Now, the survivors were not happy with this. The survivors then filed a writ petition before the Apex Court. The Apex Court back then said that first of all, Azam Khan should give an unconditional apology and also said that the case has raised serious concerns regarding the state obligation which they have towards the citizens and the freedom of speech and expression. They can say anything in the in the Parliament or the Legislative Assembly. Now, the parliamentary privileges and other immunities are mentioned under Article 105 and under Article 194 of the Indian Constitution. Under Article 105, it is with respect to powers, privileges and immunities which are given to the member of the Parliament, Lok Sabha and Rajya Sabha, and under Article 194, similarly to the state legislatures, their members and committees. And they can practice, the MPs and MLAs can exercise the powers under these two articles only during the period for which the person is the member of that house. And it is necessary, it is sometimes seen as necessary for exercising constitutional functions. Why? As a parliamentarian, as a member of the Legislative Assembly, it is important to hold the executive accountable to the Parliament or the Legislative Assembly. So I can say anything responsibly and in a parliamentary fashion in order to ensure that the executive is accountable to the Parliament and the Legislative Assembly that has been dictated in the Constitution. So for that, I cannot be charged. I cannot have any sort of police action against me because it might be possible that the executive is going to misuse the power it has for escaping accountability and transparency. Okay, so this is the reason why they are provided such immunities. Now, other important immunities and privileges are, of course, freedom of speech in the House, where the parliamentarians as well as the MLAs, they are free of any repercussions. Of course, political repercussions could be there or the media repercussions could be there, but there would not be any sort of repercussion with respect to whatever they say in the Parliament or the Legislative Assembly in reference to the debates that are going on in the Parliament or the Legislative Assembly. They are exempted from civil or criminal liability for any statement, mind you, for any statement made or act done inside the House in the course of their duty. So, inside the House and the course of their duty. Two important premises. They also enjoy freedom from arrest, which is 40 days prior or 40 days after a session of the legislature, or during the session, or from the premises of the legislature, until and unless the leader of the house decides otherwise. The legislature has the power to regulate its internal affairs, and that is why these particular immunities and privileges are sometimes used irresponsibly. Now, free speech of the need, if we talk about free speech of legislators, protect the integrity of deliberations in the parliament. First of all, integrity means parliament is it's a mini nation. It's a highly respected body. So, if any sort of action because of the freedom of speech is taken against any parliamentarian or the member of the legislature or any member of the legislative assembly, it would harm and breach the integrity of such a respectable body, because it is a respectable body according to the constitution, and of course in a parliamentary democracy it is. Also, the freedom of speech is a shield against executive suppression and inconvenient voices. Now, one thing that we have to ensure is whenever we are electing our political leaders, we should be mindful of the fact that they can ask anything to the executive in the course of their duties. And in order to ensure that my question, which is being asked through my elected representative in the house, is respected, it is not suppressed, and of course it is the work of the opposition in a parliamentary democracy to hold the leaders in power accountable. So for that also, the policing of legislative speeches will severely impact the ability of the parliament. If anything said or done, even if it is said in a respectful and responsible manner, if the executive could suppress it, then the parliament as its essence will fail. The parliament will fail to do its basic duty to ensure proper policy making, to ensure proper law making, to ensure better transparency in the implementation of that law. So this is also what we have to think about. And in any liberal democracy, it is important that debates take place. Debates are sometimes heated. So in order to prevent any sort of disruption during that also, any sort of threat mongering during that also, it is important to give them freedom of speech. But now let's talk about the concerns. See, there have been incidents where leaders and representatives in the parliament have used very wrong terms. They have used unparliamentary language, unbecoming of their status, and of course, it is such a shame that it is increasing. Also, there has been a continuous rise of hate speech, which is dividing the nation as a country, and that is not very good for the moral as well as social fabric of our country. There are growing instances of bribery of legislators because of the particular phraseology of Article 105, Clause 2 as well. Now, there is, of course, continuation of hate speech and the incidents of unparliamentary behavior, which is much more disturbing of all the three. If we have to discuss the judgment, the current judgment, majority, there was a dissenting judge. The dissenting judge is the first to be Women Chief Justice of India, Justice B.V. Nagaratna. So what she has said is in dissent of the majority judgment, but the judgment said that there was a big question mark to the case, whether restrictions can be imposed on a public functionary's right to freedom of speech and expression, whether this could be done. Because in our terms, I am just a normal citizen of India. I exercise my power of freedom of speech. I exercise my right of freedom of speech due to the presence of Article 19. But there are reasonable restrictions. Reasonable restrictions are pretty subjective in nature. Those speeches could not be hate speech. Those speeches could not disturb the peace of the country. So for that purpose, there are reasonable restrictions. But for the parliamentarians, public functionaries, or the MLAs, there is no such thing. So this was the question that was asked. So a statement, the majority says, a statement made by a minister, even if traceable to any affairs of the state or for protection of the government, it cannot be attributed vicariously to the government by invoking the principle of collective responsibility. In simplistic terms, let's understand this. The statement, suppose it is made by certain minister, but now that cannot be attributed as it is being said by the entire cabinet, and now we cannot invoke the principle of collective responsibility. Vicariously means to substitute. Let me make you understand this with the help of an example. Supposedly, your daughter or your son becomes a big star. Now, the big star is famous. He or she is a celebrity now. So what happens as a parent? You could be also living that glamour, that celebrity status vicariously. It's a second-hand, you can say, it's a second-hand enjoyment of that celebrity status. Similarly, we cannot say that because Azam Khan said that statement, it might not be the responsibility of the entire cabinet. We have the principle of collective responsibility in the parliament, right? So, the action of one minister will bound the entire set of ministers. But now, at this particular premise, the majority said that it cannot be done in that manner. If any speech has been made by Azam Khan, it is the responsibility of Azam Khan, but not the responsibility. We cannot invoke the principle of collective responsibility over here, because it is being said that, of course, he said it, then by second hand, the entire cabinet, the entire party is also saying the same. This is what the Supreme Court said. Now, while citizens had the right to petition the court for violation of Article 19 and Article 21, a statement made by the minister inconsistent with the rights of the citizens may not itself be actionable. But if it leads to omission or commission of offence by a public official, then remedies can be sought against it. Okay, this was the dissent. And freedom of speech and expression is a much needed right. Why? Because it gives education to the citizens as well as the parliamentarians to be educated on governance. Then further restrictions need not to be placed. That was the dissenting slide. This Justice B.V. Nagaratna was the dissenting judge over here. She said that there is not a need of further restrictions to be placed. Okay, so freedom of speech and expression is much needed. She has said that. Also, common law remedies are already present to address those issues. She also said that. Creating another set of guidelines or law is a matter of Parliament to deliberate, not something that the court would say. If the statements are disparaging, the government is vicariously liable. She wrote in her opinion, this is where she differed from the rest of her bench members. Okay, so she said that if a person of your party is making such statements, then of course it can be attributed vicariously, and then principle of collective responsibility can be invoked. This is where she dissented. Now the conclusion is that whatever privileges and responsibilities we are giving to our representatives, that should be of course exercised in a responsible manner, in a manner in which it is not satisfying for the ego, not escaping responsibility and accountability, but at the end for the welfare of the citizens. It should enable them to perform their functions without any hindrance, fear or favor. This is second most important. Then any ecosystem that encourages irresponsible speech or turns a blind eye to corruption must be uprooted entirely. And who is responsible for that? First, the party. Secondly, most importantly, in fact, I must say, it is the citizens, because it is our responsibility to send well-read, educated, responsible, well-articulated people to our parliaments. We just succumb to power, we succumb to short-term goals, we succumb to greed. But it is at the end our responsibility, if we have to ensure that the parliament works in a responsible manner and the freedom of speech is not being used as some sort of blanket to escape their own egocentrism, we should ensure that we are sending the right people in the parliament. Let me take the names of those who have answered the last question correctly. Jainism was the correct answer. Hope Esthiam, Prasanna Pratik, Raghavendra Puneet, Muhammad Shahwyaz Khan, Snehalata has answered it correctly. Rupal, Soumya, Rahul, Raju Mandal, Simran, Kumar Satya, Akansha Singhal. Apart from them, who all have answered it correctly, Sagarika has answered it correctly. She has also answered the another question, Chetak, about Chetak. So, very good for that. Also, Anuj has answered it correctly, Shruti, then Tushita, Pallavi, Saundarya, Pramit, also Shirley and Bhargavi. Congratulations for answering the last question correctly. Again, answer this current question that I am attaching in the comments segment. Thank you so much for watching and stay updated.